So hello everyone and welcome to today's webinar. My name is Stephen Lowry. I am Public Policy Manager here at the Institute of Chartered Accountants. I'm delighted that so many of you could join us here this morning for what I'm sure will be a really interesting discussion. Now, the title of today's webinar is Navigating Ireland's New Protective Disclosure Law, and there certainly is a lot to navigate. But thankfully, I have with me today a panel of experts who will be able to shine a light on the key tenets of the legislation that you need to be aware of, as well as providing what I'm sure will be some valuable experience share in how they have found implementing their own whistleblower policy in their organizations following the introduction of the legislation. So I will just begin by running through who is joining me here today. I'm joined firstly by Barry Robinson, who is a director in BDO and leads BDO's Forensic Services team here in Ireland. He is a member of BDO's Global Task Force for Whistleblowing and Protected Disclosures. Barry has assisted clients in understanding the practical implications of new whistleblowing legislation and provides fraud awareness training to companies and operates reporting channels externally on behalf of clients. We're also joined by Michael Deeney, who is an experienced compliance officer, having served as Chief Compliance Officer at 3 banks and 2 aircraft lessors, including organizations with Irish, US, German and Chinese ownership, both public and private. Michael's particular areas of expertise include the design and implementation of compliance programs in companies with multiple international locations, compliance operational risk assessments, compliance training, AML and anti-bribery. And lastly, we're joined by Annie Demred, who is VP for Strategy and Growth at WhistleLink. WhistleLink is a web-based whistleblowing solution provided to companies and organizations in Europe in over 30 languages. And Annalie's particular area of expertise is assisting companies to set up new reporting channels and give those tasks with overall responsibility for the reporting channel, the training and tools necessary for this important role. And Annalie, at the end of this session, will be able to provide some valuable insights into that online solution in providing a demo as well, which we hope you'll find useful. Now, before again I kick into the meat and substance of today's panel discussion, I will just mention this legal disclaimer that we remind listeners and users that any of the material that we're providing and resources and general information only on the topics and material covered. We are not providing legal or other professional advice or interpretation of any definitive legal interpretation or opinions on any legislation or legal or other matters. If the user is in any doubt on any matter in this complex area, legal or professional advice must be obtained. So with all of that said, I can now turn to our first speaker, Lillian Halpin, who works as Technical Manager here in Chartered Accountants Ireland. Lillian is a qualified solicitor and has worked in the corporate banking and restructuring space for many years. She now monitors new regulatory and legal developments affecting accountants with a view to providing information to members. Now, Lillian is going to provide a really useful overview of what the nuts and bolts of this legislation says. So take it away, Lillian.
Many thanks, Stephen, and thanks for that introduction. So my plan is to spend approximately up to about 15 minutes or so giving an overview of the applicable Irish legislation on protected disclosures and to mention a few other items of interest to listeners in the area. So most people on the webinar are likely to be aware that while Ireland has had protected disclosures or whistleblowing legislation since 2014, that there have been recent changes to that legislation. So the Protected Disclosures Amendment Act of 2022 was commenced in January of this year, 2023. It was brought into force to comply with Ireland's EU obligations under an EU whistleblowing directive that was adopted in 2019. And you're going to hear me referring to that interspersed in the conversation there further on. So under the amended protected disclosures legislation, there's been a considerable broadening of some of the definitions that was in the previous 2014 legislation. So I'm going to go into a bit more detail about that now. So the first thing to consider is what is actually a protected disclosure. So under the amending legislation, there's a few elements that we should be touching on to describe it. A protected disclosure is described in the legislation as a disclosure of relevant information. Relevant information is information that in the reasonable belief of a worker tends to show relevant wrongdoings and came to the attention of the worker in a work-related context. So I think that reasonable belief would have to be subjectively believed by the person disclosing, and it would have to be objectively reasonable as well. It doesn't have to turn out to be true in the case of your disclosure made to your employer. So if a disclosure is made to a person who's not your employer, so if you use other procedures in the legislation, such as, say, to the Protected Disclosures Commissioner, for example, then there is a higher standard put on you there, and there is a requirement that there's a substantial truth in the allegation. Now, turning to the definition of worker then, so who is the worker who can gain protection under the legislation? And that's been amended and widened by the 2022 Act as well. The definitions now specifically mentions the public and the private sector, and it's not just employees who are protected. The amending legislation brings in the shareholders in an organisation, people on work experience, members of an organisation's administrative management or supervisory body, could be volunteers, potential recruits, or persons acquiring information during pre-contractual negotiations. So the type of person who can make a protected disclosure is now much wider. Then turning, and these points are, there's just 6 little, sorry, the next slide, yeah, thanks, Jerry. The next, so these are the elements here of the protected disclosure. So turning to the relevant wrongdoing element, again, that was defined, and it was defined in 2014, but it's been widened pursuant to the new legislation which fell out of the whistleblowing directive. So so as well as the current, what used to be under the 2014 Act, wrongdoings that an offence had been committed, is being or likely to be committed, person failing, likely to fail or comply with a legal obligation, health and safety of an individual being or likely to be endangered, or improper use of funds of a public body or public money. So those have been added to further relevant wrongdoings, one of which is that a breach has occurred or is likely to occur. And again, this refers back to the EU whistleblowing directive, which it cross-refers back to the annex of the whistleblowing directive. So if there's breaches of legislation in particular areas found in the whistleblowing directive, such as in the area of public procurement, transport safety, public health, financial service products and markets, preventing money laundering and terrorist financing, anything a breach of the legislation in those areas is a relevant wrongdoing which can be reported on, and the whistleblower gets protection provided that the other elements that I'd mentioned are there. Then just touching on the work-related context. So I had said that the information on the relevant wrongdoing comes to the worker must come to the worker in a work-related context. This is a new term again in the amending legislation, and it's interesting to note that it refers to current or past work activities in the public or private sector through which somebody acquires information concerning a relevant wrongdoing. So it could extend to somebody who had previously worked for the organisation and had moved on. So turning then to what is the whistleblower protected against? And there's 2 elements to this. One is that the whistleblower is protected against unfair dismissal, and the other is against penalisation. So on the unfair dismissal, I would just say that it is a particular specialist legal area. So if you're delving into this, you probably do need professional legal assistance. But there's a couple of things to note: that the Protected Disclosures legislation amends the Unfair Dismissals Act, and it provides that a dismissal of an employee is deemed to be automatically unfair for making a protected disclosure. And there's a presumption in the Protected Disclosures legislation until the contrary is proven that a disclosure is a protected disclosure. So if it's an unfair dismissal claim under the if it's a protected disclosure, you don't need to have had 1 year's continuous service for making an unfair dismissal claim for a protected disclosure. So that's helpful to the employee as well. And the usual ceiling of 104 weeks compensation doesn't apply there. It's actually 260 weeks. So it's not 2 years, it's actually 5 years. So the other element of what the whistleblower is protected against is penalisation. And this amended legislation, the amending legislation, again, driven by the directive, has expanded the definition of penalisation. And there were instances of penalisation previously in the 2014 Act, such as suspension or layoff or dismissal, unfair treatment. And to those have been added the concepts in the directive, such as withholding of training, negative performance assessment, converting a temporary employment contract into a permanent one, where there would have been a legitimate, not converting a temporary employment contract into a permanent one, where there would have been a legitimate expectation and blacklisting an employee. So there's a new widened definition of that. If there's a penalisation, you can make a complaint to the Workplace Relations Commission. There's a cap of 260 weeks on the remuneration there. And for people, as I mentioned, workers can be volunteers who wouldn't necessarily be in an a paid employment relationship. So in those circumstances, there's a cap of 15,000 for such a person who is not in receipt of remuneration in the work-based relationship. So, and just finally on the unfair dismissal stroke penalisation side of things, whereas previously you could only look to the Circuit Court for interim relief in the case of an unfair dismissal, you can now, since the 2022 Act, look for interim relief in the case of penalisation as well. So that's the elements of the protected disclosure. So now I'd just like to turn to the biggest change, I think, that has been brought about by the amending legislation. And this is the requirement for organisations of a certain size to put in place an internal reporting channel and procedures. And previously this had only applied to public bodies. Now I know that other speakers are going to go much more into the practicalities of these internal reporting procedures. So I'm just going to outline some of the requirements as to the organisation size-wise, which must have a channel, when they have to have it from what date. And then I'll very briefly run through some of the elements of the reporting channel. So I'm just going to very briefly take you through the slide on the screen there. So if you have an organisation, which is a small organisation under 50 employees, and that organisation is not a public body, or it doesn't fall within certain sectors that are scoped in by the directive, and those sectors are financial services, products and markets, preventing organisations that will be involved in preventing money laundering and terrorist financing, organisations in the transport safety area and protection of the environment. If it's not one of those organisations, or it's not and it's not a public body and it's under 50 employees, there is no requirement to put in place an internal reporting channel. If it is that public body or those sectors that are scoped in that I've just described, then you have to have a reporting channel in since the 1st of January this year. Then also large organisations, which are 250 or more, they have had to have reporting channels in since the 1st of January this year as well. And then medium-sized organisations between 50 and 249, which are not public bodies or the certain sectors that I mentioned, they have a bit of a reprieve, and they will have internal reporting. They must have their internal reporting channel by the 17th of December of this year. So that's the size-wise and so forth. And I would like to just emphasise that the cut-offs and obligations and putting in reporting channels is one thing that certain organisations have, but the provisions of the legislation apply to all of, the expanded definition of worker, the widening of the definition of penalisation, for example, they apply to all organisations. It's just the reporting channels one that are those particular ones. So then turning to the elements of the reporting channel, just very briefly, as I said, other people will be talking in much more detail, practically speaking, about the internal reporting channel. But it must be established and operated in a secure way. It has to facilitate reports in writing or orally or both, provide for oral reports by phone, voice message or meeting if requested by the reporting person. You have to acknowledge in writing within 7 days of receiving a report. You have to appoint an impartial person to investigate it and to give feedback within a reasonable period. And a reasonable period is usually 3 months under the legislation. Feedback is defined, but it's vague. It means the provision to a reporting person of information on the action envisaged or taken as follow-up and on the reasons for such follow-up. And the reason why I say that I think that it's a bit vague is that I don't think, for example, that it would mean that a whistleblower could rock in and say, well, what penalisation or disciplinary measure did you apply to that to that wrongdoer? I'm not sure that they're entitled to that information. So organisations will have to navigate and measure up what information should or shouldn't be given out. And some of the other speakers may have some more practical take on that side of things. there's a whole new suite of offences and penalties brought in by the new legislation. I'm not going to go into them all because other speakers are dealing with different things. I'll just say from my point of view, from what I've mentioned, that two jump out. One is that it's an offence to hinder or attempt to hinder a worker in making a report. And it's also an offence to penalise or threaten penalisation against a reporting person or others set out in the amending legislation. So there's others as well, as I said. The penalties for those ones are a Class A fine, which I believe is €5,000, and or 12 months in prison. That's for on summary conviction, which is a lesser offence, or on conviction on indictment, which would be more serious, a fine not exceeding 250,000 and or 2 years in prison, or both. So just to then, if I just could have the last slide there, just to say that what we've been doing in the Institute, just to bring a couple of things to your attention, we've recently put together some resource pages on protected disclosures. I've given you some links there. The pages are located in our technical hub, and at the moment there's 4 of them. We've one for the Republic of Ireland, one for the UK and Northern Ireland, where the legislation is different, and there's a review ongoing in the UK for whistleblowing legislation at the moment. And then the other 2 pages are on the new reporting requirements, which I've just talked in a little bit of detail about. And finally, there's a resource page that we gathered the likes of articles and webinars, particularly on the coming into force of the new legislation. So those pages are there. The Department of Public Expenditure and Reform have issued interim guidance, which I think is very good. It's stated to primarily assist the public sector in implementing the Act, but I do think it's a very good guide for reporting channels, and there's various other matters that it's well worth consulting if you're trying to get up to speed or looking for some more information in this area. And finally, the Institute Business Law Committee, which is part of the consultative group of accounting bodies, intends to publish a help sheet or guidance for members on protected disclosures. So we expect to have that before the end of Q2, and it'll be available on the website when it's finalised.
That's really great. Thanks, Lillian, for that really helpful overview. There's a lot there to get through, and you got through it well. Let me ask you a follow-up question. I think a lot of people will be wondering about is, when we're bringing in these new policies, is there a legal obligation on organisations to provide training to deal with protected disclosures?
Well, I think that training will be very important for organisations. I think that it will be the designated person who's taking the reports would need to know how to deal with it, and there should be an awareness of the systems and procedures, and training for managers to recognise that something might actually be a protected disclosure and react to that. There is some reference in the legislation to training, but I think that's in relation to external reporting. I'm not sure there's a legal obligation as such, but I definitely think that it is something that would be prudent to make sure that the organisations, recipients of the protected disclosures, or anybody else involved would know how to deal with it, would recognise that something that comes in as a grievance might actually be a protected disclosure, and that it might need to be dealt with in that certain way. So even if it's not a legal obligation, I think that it's definitely something that the organisation should do.
Yeah, it would be prudent to do, absolutely.
Stephen, sorry, Michael,
yeah.
Could I just comment on that? We implemented a procedure or a system some time ago, and I would fully agree with Lillian. It's very important that the people who receive the cases are trained and have a procedure to follow, because they may not be, it depends who they are, but they may be senior people not directly involved in dealing with these kind of matters before. And as Lillian mentioned, there are deadlines in the legislation. There are certain requirements. You have to keep the report raiser's identity confidential, etc. If they don't do that, that's going to bring other problems. So I think training is key.
I think that's a great point. And Lillian, one additional follow-up question, if you'll allow me.
Sure.
In the context of this new legislation, how are, say, interpersonal grievances dealt with? Is there a particular, is that covered specifically, or how is that dealt with?
That's a good question, Stephen, because there is this distinction for interpersonal. Interpersonal grievances are ones that affect the the person only, such as, for example, your training contract or whatever. And the 2014 Act, so your own terms and conditions, for example, but the 2014 Act didn't make any distinction between an interpersonal grievance and protected disclosure. And then there was unfortunately a code that was brought into force which did make the distinction, said, well, look, an interpersonal grievance can never be a protected disclosure. And that was litigated in 2022. And the Supreme Court struck it down and said that that isn't what the legislation says. So now, under the 2022 Act, they've specifically excluded interpersonal grievances from the protections in the legislation, and that matters exclusively affecting a reporting person concerning an employment grievance is not a protected disclosure and may be dealt with under other grievances or complaints procedures. So I think that actually, that Department of Public Expenditure and Reform guidance that I mentioned there, I did find that there is some very useful stuff there in if people are looking in for guidance in this area. It contains some guidance on grievance and dignity at work procedures and how to deal with interpersonal grievances. But as I said, it's dealt with specifically now in the 2022 Act, whereas it hadn't been before. So.
Yeah, no, that makes sense, and certainly an important area to be covering. Well, look, let me thank you, Lillian, for that really insightful overview. It kind of sets the stage of what we're talking about today. And I'll just bring in next Barry Robinson, who's a director in BDO. Now, Barry, you've assisted clients in understanding the practical implications of the new whistleblowing legislation, and you've extensive experience in that area. So let me begin by asking you, what do you feel are the key issues businesses need to consider when implementing their own internal or external reporting channel?
Thanks, Stephen. I suppose everyone on here who's interested in learning about the legislation and want to know about how to implement it and how to become compliant, they often start with looking at their own organizational culture, and they say, well, why do I need to do this? Why do I need to comply with this legislation? And so there's sort of two aspects to that. One is it's good, it's part of public policy, there's a legal requirement to do it, but actually often not publicized are actually the potential for criminal sanctions to organizations for not implementing it. And that is quite, it's there in the legislation. And I suppose I'd encourage organizations considering what they need to do, first of all, to really study and go through the legislation and get some guidance. And I think this webinar hopefully will go some way to achieving that. But the criminal sanctions fall under sort of two areas. One is what happens if you breach the confidentiality of the person reporting the wrongdoing. And then, so that brings itself its own criminal sanctions if you breach that confidentiality, and it's fines up to 75,000 to 250,000 and imprisonment. I mean, these aren't light sentences. But also then, what happens if you fail to establish or maintain or implement a reporting channel at all? And again, the legislation is very clear that says that there are these criminal sanctions, the same levels, up to 250,000, 75,000 and imprisonment. And these are, this legislation is kind of standalone. It's separate to the Companies Act. It's separate to your Director Statement of Compliance. And it's really that understanding of what happens if we don't do anything is really important consideration for companies, compliance officers, accountants in organizations. The second piece is, well, what do I need to be mindful of? How do I actually achieve that? And it's this requirement to establish a internal reporting channel. It has to be compliant with GDPR. It has to be given to designated people. So another consideration is, who in my organization is going to actually be responsible for this? And, you know, hopefully we'll hear from Annie and Michael later in the presentation about how and what solutions there are out there. But often it's that organizational change that everyone's responsible for this. We want to create an environment and an atmosphere where people feel that they can actually report, that they won't be penalised, like Lillian talked about, the protections built in, but that any report that will be made in confidence. And I always advise clients and businesses that if you had serious wrongdoing going on in your organization, you know, you really would want to hear about it, and you want to make that process as easy as possible for people to come forward, to take that step. You know, the companies that I've seen the other side where there has been wrongdoing, go in and investigate that, but it's about putting yourself in the shoes of the person who feels that they have an obligation to bring this to the senior management of the organization, and to make that as easy as possible for them. You know, we talked there about training. I think that is an important consideration. There are requirements under the Act that the person responsible for the internal channel should be independent, should know how to operate the channel, should maintain, you know, be conscious of GDPR and confidentiality, and they should be aware of the reporting timelines. You know, you have 7 days to go back to someone and say that you've acknowledged receipt, but also then you have 3 months to actually undertake a review or an internal investigation to decide whether or not wrongdoings occurred, and then you have to provide feedback to the person under the legislation as to what the outcome of that was. And how you do that is an important consideration. The last consideration I'll mention is whether organizations feel they want to opt in to receive anonymous reports or not, and how they do that. Lillian covered very well the 4 kind of methods by which a person under the law can report. So that's in writing, by phone, they can ask for a meeting in person, or through another, you know, kind of secure internal reporting channel. And it's that the law actually in Ireland, under the EU directive, it gave Ireland a choice as to whether companies had to accept anonymous reports or not. And in Ireland, we actually decided that if an anonymous report was provided to an organization, it could stop there. There's no obligation placed on companies to accept or follow up on anonymous reports. But, you know, Michael and Annalie might give their own views on this, but, you know, if a person didn't feel comfortable giving their name and it was of such a serious nature, and you did get an anonymous report, you might still decide that despite your legal obligations, that you don't have to follow up, that you may wish to accept it and acknowledge that despite what the legislation says, you feel that there's merit in looking into that. So anonymity and anonymous reporting is a huge consideration for companies.
Yeah, Barry, I would agree with that. What we did was in our procedure document and guidelines document, we said to anybody that if they wanted to raise a report anonymously, they could, and we would review it, but we did not, we reserved the right to act on it or not. And what we kind of said was, we would much prefer if you would give your name, because then we can actually potentially ask follow-up questions.
Yeah.
And we can also report back to you much more easily on any action that's been taken on foot of the report.
And Stephen, just to close off on the final considerations, Lillian's covered off who the category of worker is and the broad categories. So it's a worker, an employee, a contractor, an agent, a trainee, a volunteer, or a job applicant, and shareholder and directors of companies as well. So the consideration is how and in what form can companies then make their policy known to these categories of people who are outside the confines of employment contracts. And you know, I hope Michael will cover off and Annalie how that can be done, but that's a consideration. How are you going to communicate your policy and bring those broad categories of workers into the fold, into the knowledge, because they won't have access to an intranet. They might not have an internal email policy, and therefore that's a consideration. You know, how they can actually report through the internal channel.
That's some really good points there, and Barry, and some confidentiality obviously is key, and knowing who the designated person is in your organization and that they understand their responsibilities is also really important. So that's really, really helpful. I think, Michael, I'm going to bring you in now. Michael, an experienced compliance officer who's actually had experience implementing his organization's own whistleblowing policy. So, Michael, I suppose to open with, and there's a lot to touch on here, but what were the main drivers for implementing an external whistleblowing solution?
Yeah, thanks, Stephen. Just before I get into that, Stephen, can I just make one point? Barry commented on culture, and I think a good example of this area is so topical. Some years ago, I'm sure some people on the call will remember, there was a CEO of a UK bank was fined personally by both the UK regulator and by the bank itself, and the bank has also clawed back part of its bonus for attempting to identify a whistleblower. So the whistleblower was not identified. He took steps to try and identify them, and he got sanctioned for it. So, and that was public. That's public domain. So I think that just shows cultures are changing. In respect, in the company I was working for, Stephen, at the time, this was a company in the bracket of between 50 and 250 employees. So we were conscious of the legislation coming out last year. We started working on this probably around the end of Q3. We found it a reasonably easy thing to do. Of course, you wanted to comply with the legislation, so that's like a key driver. But we interestingly found two side benefits, unexpected benefits from it, which we weren't expecting. First of all, I'm sure many people on the call will be familiar with SOX programs. Hopefully that doesn't give them shivers. We were owned by a Chinese company who were implementing CSOX. So the implementation of an external whistleblowing solution actually ticked a very large box for that. It would have been a problem if we had not had an external whistleblowing solution. So that was a pleasant benefit, if you like. And the second part was the company was implementing quite a detailed ESG program, and was in the process of drafting its first ever sustainability report. The whistleblowing solution actually ticked a very large box under the G part. Okay, so I should have prefaced my remarks by saying this company had never had a whistleblowing case, so it was new for them. But then when they were, as I say, drafting the ESG report, and they were actually getting scored on their ESG program, and the external consultants who were scoring it said, yes, having an external whistleblowing solution is a very positive thing, and not having one is a negative. So if you like, the drivers for us were, number one, first of all, comply with the legislation. That's a given. But then we also found two very pleasant benefits from doing it.
Absolutely. And I suppose, when you're implementing change of this kind of, magnitude, this kind of order, it's an important change. You need organizational buy-in. You need people to really feel a part of this, feel invested in it, have confidence in it. How did you steward that? How did you seek to kind of garner that from the organization when you introduced this?
Well, there are a couple of things. So previous speakers have commented on the range of new stakeholders who can, or the range of people who can raise a concern. So we kind of divide them up into external and internal. So how best to roll out the program to all those people? We had to deal with internal departments such as HR, IT, and the C-suite. So obviously, again, the C-suite, given we'd never had a whistleblowing case, I did actually get the question once, why are we doing this? Do we have to do it? I said, well, yes, there's legislation. And for the reasons I raised before. What we found in terms of rolling it out to external stakeholders, the best way we thought we could do it was to put it on our website. So talking to the IT department about how to do that, putting up a link on the website, and then the guidelines. If you click on the link, you get to certain guidelines, and they tell you what to do. So, and just in terms of the internal piece, talking to our HR department, the company had an employee manual, a staff handbook, if you like. That document talked at length, and Lillian mentioned grievances. The company had grievances, and there was a procedure for that. they didn't. The idea of whistleblowing wasn't really mentioned or wasn't really covered in the handbook, and now it had to be. So there was a lot of, as you can imagine, and the handbook is owned by the HR. What in our company was owned by the HR department. So there's a lot of interaction with them, how best to describe the whistleblowing solution, and what it should be used for, that it shouldn't be used for grievances, to make that very clear for employees. And then, of course, actually rolling out the overall solution. That was, there was a town hall meeting had. People were invited to attend. People were invited to ask any questions they wanted. They could come and talk to us bilaterally afterwards. So, yeah, there was a large number of internal and external stakeholders involved.
It seems like like that kind of campaign is required, getting that kind of communication out there, communication being key to getting that kind of buy-in. And as you're saying, some really good points there about this communication at various levels, at the various stakeholders, be it HR, C-suite, the general employee population. Before I pass on to the next speaker, Michael, can I press you for, do you have any top tips for people who, from your, having come through the other side of what you would kind of say, I have found this was a particularly beneficial route to take when I approach this? For anyone who might be undertaking their own whistleblowing legislation, policy journey.
I would go back to something that Lillian mentioned in her remarks. Again, I come back to training. I mean, so we identified very early on in the process, we decided, okay, there are 3 people, and they are senior people who, if a case came in, they would be directly responsible for reviewing the case and deciding how best to respond. So you can probably guess 3 of the people were the 3 people were our general counsel, CFO, and COO. Okay. Now, and then those people, and then there was an escalation point. So if those 3 people couldn't really decide, or if one of them was potentially involved in the case that was being raised, there was also an escalation point to the CEO, and the CEO would eventually decide how best to deal with it. There was a very detailed procedure document drafted. So to give these people reassurance on, if a case comes in, this is exactly how they should behave, and this is how they should react. And Barry mentioned certain deadlines. The key, the absolute criticality of keeping the identity of the concern raiser is crucial. A company can get into very big trouble if they don't do that. So the tips I would say is identify the people early, train them, and have it documented exactly how they should behave.
There are some good tips. Thank you, Michael, for those insights. And as I say, the purpose of today being not just to provide you an overview with the legislation, but also to get this valuable experience share from experts like Michael. So thank you for that, Michael. Now I'll just move on to our last speaker, Annie Demred. And Annie, you're very welcome into the room there. Annie is the VP for Strategy and Growth at WhistleLink, and WhistleLink provides a web-based whistleblowing solution to companies and organizations across Europe. You're very welcome, Annie, and thanks for joining me here today. Now, I know actually at the end of this webinar, you're going to give a demo of this digital solution, which I think will be particularly interesting. But just before we kick into that, in terms of your own process, when people come to you as a new client, they say they're looking for a whistleblowing solution. What does the onboarding process typically look like? And I suppose the second part of that question would be, what's the kind of general time frame people are looking at?
Great question. So yeah, very much mirroring what Michael just said and what Barry said. We try to be really agile and adapt accordingly to who we have in front of us. And we work with all kinds of organizations of all sizes. So, of course, what they need from us, what kind of support the organizations we work with need, so different. So, as you know, organizations starting from 50 employees and upwards, what they bring to the table is so different, and also what resources and what capacity they have in-house. If you have a legal counsel in-house, they would run with this. Maybe they have also the funds in place to seek external support from an organization, a person like Michael or Barry. If you come kind of clean to the table, you don't know where to start, but you want to be up and running as soon as possible, my experience is that an average implementation phase is somewhere around 2 months. From our perspective, like from a technical standpoint, rolling out the internal reporting channel, our web-based solution, we can be up and running in a day. But you need that, as Michael said, that buy-in from stakeholders. You need to create, even if it's not as detailed as Michael's, you still need to have a rough understanding on the procedures. What should we do? And you definitely need to educate not only the designated persons, but actually also the people who are entitled to report, the people who are protected by the law.
Absolutely. Sorry, go ahead.
No, that's it. I'm good.
Yeah, no, I suppose what you're touching on there is an important point. It's something that Barry really brought to the fore: confidentiality, making sure that's adhered to, staying within GDPR regulations. How do you make sure that all that data is kept safe and in accordance with those rules? It's obviously of a high priority to the organization. There's a risk of reputational damage if that's not done. If they're subcontracting the site to you, what measures do you take to kind of adhere to that?
So at Whistlelink, we have been delivering whistleblowing solutions for nearly 10 years. So knowing from a long time ago that information security is super important. And since GDPR regulations came into effect across Europe, obviously even more focus on that and data. We have our hosting in Sweden and inside of Europe. Our company is ISO certified within information security. And we work a lot with partners and also together with our clients to together make sure that data is protected. There is, of course, only so much we can do from our side, but there are also humans on the other side using our services. And if they don't keep their accounts protected, enabling two-factor authentication, making sure that the data stays within the software and maybe not print it, not share it, with a wider group, it's a joint work. Training, education, and of course, for us, just making sure that we always are running in front.
Yeah, absolutely. Sorry, Michael, do you want to come in there?
Yeah, and I will preface my comment here is that I am not on commission for Annalie, but I did find we used Whistlelink, and I'm aware there are other solutions out there, but what we liked about Whistlelink is it was very customizable to what we needed. We could even put our own branding on it. So we were able to put photographs that we chose. And so if you click on the link, you get to see our company logo and you get to see our company photograph and all that kind of. We found that quite good and frankly, good value for money. It was not an expensive experience. And I'm not on commission.
a ringing endorsement there from Michael. Annie, I'm just aware that we are, we're talking about this in very, abstract terms. It would be interesting to get a kind of an actual real life example of how this solution works. And it being 11:15 now, I don't want to squeeze you for time. So let me hand over to you to run through a demo of the software, which I think the attendees would find pretty interesting.
Thank you. Yeah, I'll share my screen and we'll have a quick look of what an implementation could look like. It's a made-up organization that I use for demoing purposes. And as Michael said, there are a lot of providers out on the market. When evaluating, you need to find your own checklist, what's going to be on your, what ticks your boxes, so to speak. But speaking for all vendors, for all software providers, they will help you to make sure that you comply with the new regulations. Your data will hopefully, depending on vendor, maybe stay safe and secure. It will be easy for you to comply with GDPR regulations. and also with other aspects, as I think both Barry and Michael mentioned, that are in the regulation. Time frames that you need to adhere to, that you need to safely communicate with the reporting person, and so on. So have that in mind when we look at the demo. I also encourage anyone to ask questions. We have a Q&A button below, and yeah, feel free to interrupt, and my colleagues in this call will help me to share it with me. All right, do you see my screen now? Can you confirm that, Stephen?
Yeah, you can see that. Yeah.
So Wizolink, our software for reporting, it has two components. It's the reporting page where any one of these people that Lilian and Barry mentioned who are entitled to a report, protected by the law, would come and find information about the organization. It is highly customizable. My company here, Basker, has their own logo, and you can also in all way change and adapt the texts. On the other component is the case management system. So any report submitted here would end up in a protected, closed environment where just a few designated people would have access the report, to read and take action on it. You can also see down out here to the right that the additional ways of reporting you can highlight or mention on the page here. Over phone, if you want to have an in-person meeting, or even if you want to send an old-fashioned letter. It happens sometimes, actually. Not as common as you would think, but it happens. All right, so to leave a report, you simply click on the button. And then you have a bunch of questions, and this form is also customizable. I would say that most of our clients, they do customize this form quite a bit. Picking up what Barry said here a while ago about confidentiality versus anonymity, here I have added, what is your name and contact details? Basker will keep this information confidential and not share it with any wider audience. This is a question that you can remove, of course. You can add any question. The more question you ask, the easier it will be for you to assess the report, to distinguish it from potentially false accusations, or if it's a personal grievances. This is probably a bare minimum of questions you should ask. So let's quickly fill in the report. What's your name and contact details? Within which company did the misconduct occur? Beanie hat. What is your concern about? And then there you can select the category that the reporting person believes is most accurate for this one. Handling of personal data. What do you want to report about? There has been a serious data leakage. Where did the misconduct take place? At the office. When did the misconduct happen? Last week. You can also upload files, basically any kind of files or attachments. Most common we see screenshots from mobile phones. Could be text conversations, but video, audio, Microsoft, any kind of file. Is there anything else you want to be aware about? No. You review the report, and once you're happy with your answers, you submit the report. In this case, we did ask for name and contact details, so we know who it is. A majority of our clients, they don't ask for contact details and name, so you report completely anonymous.
But that's obviously a choice then. So you know, some clients would ask for that information, others and as you're saying there, like the kind of the makeup of the questions themselves, is that just entirely at the discretion of the client of what they want to know, how little or how much?
Yeah. So whenever we set up a new organization in our system, the system comes with a subset of standard questions, and then it's up to each organization how to customize it, what questions to add, what questions to remove.
Okay.
As Barry said, in Ireland, you don't have to accept anonymous reports, which basically means that in Ireland, we see that more organizations than in other countries are adding these questions about what's your name and contact details. Of course, that is something you can fake. So what do you do then? If you write, Jane Doe, well, then it's obviously fake, and you have maybe the right to don't accept it. We definitely see organizations across Europe where the law is written, the national laws are written quite differently. They also ask for contact details because most likely it will be easier for them to assess the report.
Yeah.
But there are definitely cases where the reporting person, for so many reasons, are not comfortable to report anonymously. So, completely other topic, but that's definitely interesting. To maybe have that discussion sometime else around why Ireland has taken that route. I know the background, but yeah. So now we have submitted a report. As a reporting person, I get this case number and verification code, unique credentials. I need these credentials to come back to this page and follow up on my case. So even if you have my email and my phone number and name, my recommendation from a security perspective, from a documentation perspective, basically from a legal perspective, continue the conversation over the platform. So I'm going to save this here now. And what has also happened now is that the designated people who are appointed to work with incoming reports, they have received a notification into their inbox saying that you have a new case that needs your attention. We never share any sensitive information over email because in general, emails are considered not to be safe enough, not protected enough. There will always be a sysadmin who has access to it. So we don't share any sensitive information directly over email. I think we have a question. Should we pick that up now, or what do you suggest, Stephen? I think you're on mute now, yes, Stephen.
Oh, apologies there. Yeah, I think we do have a question. I think it's broadly more about the national legislation itself. Yeah. So I can ask that to the panelists just after we finish this demo.
Perfect. Yeah. All right. So this is kind of quickly what the process looks like from the reporting person's perspective. The URL you see here, yeah, that's the URL you would place on your website, on your intranet. Of course, depending on what industry you're in. Maybe you actually print a poster and publish that inside of a warehouse. We see all kind of ways of making sure that the information about your new reporting channel is out to everyone, which is actually a legal requirement. It's not allowed to go live and launch this and then just never tell anyone about it. So there's a legal obligation for you to communicate your protected disclosures reporting channel. Just quickly tapping into the case management system so you can see what that looks like. The beauty happens under cases. You can be in here with different user access, again, to make sure that data is protected. You can be here with full access, seeing all the cases and reading about all cases. And then you can invite maybe colleagues or external legal counsels for support to specific cases, making sure that information is kept safe. And under cases, we have all of our cases listed. They can be in different stages: new, open, closed, and deleted. deleted, of course, in accordance with GDPR. So the system will make sure that closed, already managed cases will be automated deleted after a certain time frame. You can also do a quick deletion if it's not a protected disclosure, but rather maybe a personal grievances. Maybe you mention information about other people in the organization, very sensitive. You should not keep that information as a record in any of your system. Delete it immediately. Here is my new case. There are a lot of features in here. I will, respect our times today, so I will just show you the baseline here. The first thing you would typically do when you receive a new case, and I know this for a fact, you scroll down and you read what's in the report, what has been reported about. The second thing you do is to confirm that you received the case. Also a legal obligation, no later than 7 days from that you received it, you have to make sure that you confirm the report. All conversation between you and the reporting person happens under messages. So here you communicate with the reporting person. Now an auto reply has been sent, confirming it, which is something you can enable or disable. You can also create template replies that you can use when you communicate with the reporting person. One of the most common actions when you receive a case is confirm and close, because you can easily come to the conclusion that this is not a whistleblowing matter, this is not protected disclosure. You should speak to your closest manager or whatever procedure you have in place for that. So that's a myth we can easily kill here. By far, most organizations, they receive fewer cases than what they think, and a majority of them are not to be considered as, not under the national laws. So I'm thinking very, very quick demo here, just to show you what the system kind of looks like. But I think we are moving towards the end here now. So should we leave it here? What do you think?
I think that's a very good high-level overview of the solution itself, and I thank you very much for that, Annie. I think as well, during the course of that presentation, a question came in for the panelists, and that was answered. And so to all attendees who might want to see that, that's in the chat box there, visible. But as we are now at 11 o'clock on the nose, I will just bring this to a close, which I hope everyone who has attended has found this a very useful session. I know I certainly have. I'd like to thank all of the panelists, Lillian, Michael, Barry, and Annie, for sharing their insights and their experiences. This is a dense piece of legislation, a lot of complexity there. I hope this has shed some light on some of those complexities and taken away some guidance. So with that, I thank everyone for attending, and we look forward to seeing you at the next webinar.